Call the next case, please.
Ida Steinberg versus Renea Steinberg et al.
May it please the court, my name is Scott Vincent from the Memphis Bar. I would like to reserve 5 minutes of my time, please.
5 minutes? All right, sir. You may proceed.
As the court may have already figured out, this is not the first time that this lawyer has appeared before this court on this case. My firm represents Ms. Ida Steinberg as the personal representative in the estate administration of her father. The estate administration began in 2016 and plugged along for a period of time until what I will call the sisters, which are the appellees in this case, and the sisters of Ms. Steinberg, filed a will contest, which resulted in several things happening and a lot of litigation. And this administration has been pending since 2016. A couple of years ago, if your honors will recall, at least Judge Stafford I know was on this case, I think Judge Frierson might have been as well, that there was an appeal that was filed as a result of two orders that granted attorney's fees against the personal representative of the estate that was filed by the appellees. One pertained to a Rule 11 motion, which did not comply with the safe harbor provision that I won't get into. The other one related to a mediated settlement agreement and a motion to enforce it. Fees were assessed. We ended up here. We talked about that, and there was a ruling that was when it was entered. At the time of that appeal, there was also a verified petition for replacement and removal of the personal representative, our client, as well as a finding of civil contempt against her. That was filed in August of 2020. Which
You're talking about in the trial court.
In the trial court, correct, I'm sorry. That was filed in the trial court. That was a petition filed by the appellees in this case, so the same petitioners. They were the same appellees in the prior, what I called Steinberg 1. The petition alleged that Ida Steinberg, the appellant here, had not properly carried out her duties as the administrator and fiduciary of the estate in her role as a personal representative, and looked for a finding of contempt. I'm going to jump ahead a lot because y'all may have questions for me, and I'd like to answer them if you do. But what ended up happening was over the course of the next 2 years, there were several different hearings. Testimony was taken, evidence was gathered, and the judge, Judge Webster, who is no longer on the probate bench in Shelby County, had entered a number of interim orders and ultimately had an election. And at the time of the election, that she was not reelected. Judge Townsend is now in her position. At the time, Judge Webster had set a final determination hearing in October of 2022. Well, the election happened, and then Judge Townsend took the bench on September 1st. So in between these hearings that happened, the last of which was in April of 2022, the judge had requested proposed findings of fact and conclusions of law, and the appellees had presented their version, which was 24 pages. The proposed findings of fact and conclusions of law sought to find that, number one, Ms. Steinberg, the appellant here, would have been replaced and removed, and the order went so far, proposed order went so far as to appoint another Shelby County attorney to become the administrator of the estate through conclusion. There was a finding, even though they had requested contempt in the petition, the proposed findings of fact said that that issue was moot because of things that had been done. Specifically, if you recall in Steinberg 1 of the issues was this mediated settlement agreement. Mr. Polk, who had died, the father, was a musician, a very, very famous musician. And he had some royalties that were coming in, and that was part of the estate administration. And by the time that the verified petition hearings had concluded and the findings of fact and conclusions of law were submitted, all of the royalties had been transferred, the royalty rights, so they said there's no reason for a contempt finding at that point. That was what the proposed findings said.
Both findings?
Both findings, that they said the contempt petition part was moot, but to grant the replacement and removal, and specifically appoint another lawyer. That was in the findings.
But both proposed findings of fact submitted to the trial court determined that any contempt issue was moot at that juncture.
Only the appellees submitted the proposed findings of fact.
Okay.
Does that answer that part?
It
Okay.
does, thank you.
All right, yes, sir. So, because of the election, the appellees who are petitioners on the verified petition filed an emergency motion to have the judge essentially retain jurisdiction, which the judge could possibly do by statute, retain jurisdiction over a case that had unresolved issues. Normally that's set in a trial situation, but because this was a state had been contentious, they at least asked the judge to do that. Rather than doing that, the judge entered an order and did something else on August 30th, which was the day before that she vacated the bench, August 30th of 2022. The judge drafted a 2-page order, which is in the record. I think that's at volume 7 at 944 is where it starts. And the order denied the verified petition. It said that we aren't going to remove and replace, that Ms. Steinberg has substantially Ms. Steinberg being the appellant, has substantially completed the administration of the estate. And we would have found contempt but for COVID-19, which to me is sort of like saying I found that you should have won a race but for the fact that your leg was broken. Because the world had kind of shut down. There was a finding that she maybe didn't do everything the judge wanted her to do on time, but she didn't do it because of COVID-19, so there's no contempt. The judge then assessed attorney's fees. And if reading the order, and that's really the reason why we're here at the end of the day, judges obviously speak through orders, and their orders can have consequences. Sometimes they can have consequences beyond the basic denial or granting of relief sought. In this case, the judge denied the relief sought, but granted attorney's fees to the appellees. It appears in toto, including court costs to be assessed against the estate, even though the estate hasn't been closed yet. And also assessed attorney's fees for the personal representative to her personally, as opposed to what she can seek to have assessed to her to be paid from the estate, if that makes sense. The judge then did something else, which I've never seen in a case in 23 years. The judge signed the proposed findings of fact and conclusions of law. Signed at the bottom where it says judge. She signed under where it says judge, but she signed that document separately. She made a reference and I'm not trying to be disrespectful whenever I say she, but I'm trying to keep this as simple as I can. Whenever the judge signed the order, the 2-page order, she also incorporated verbatim the findings of fact from the proposed findings of fact and conclusions of law the petitioners had submitted, and also to the extent not inconsistent with her order, the conclusions of law. Our position is that the judge could not have adopted those findings of fact and conclusions of law the way that she did. There's clear Tennessee case law, the Smith case, Tennessee Supreme Court case from 2014, that says you cannot just adopt verbatim findings of fact and conclusions of law that are drafted by lawyers unless 2 conditions are met. One is that it's not inconsistent with your order, your ruling. These findings, in fact, were completely inconsistent with the ruling. They actually found that she should be removed and replaced, with the judge found in her 2-page order that Ms. Steinberg, the appellant, should not be removed and replaced. It also found that even though she made a substantive ruling on the contempt part of the petition, she found that contempt should be denied because of COVID, whereas the findings of fact that the petitioners had submitted suggested that was a moot issue. So we would submit that the judge erred in adopting the findings of fact and conclusions of law. The judge also erred, in our opinion, in assessing attorney's fees, period. There was no basis to assess attorney's fees. To the extent that attorney's fees could have been assessed, the judge could have drafted in her own order a reason to assess attorney's fees against the estate to the appellees who are the petitioners on the verified petition, but there was no basis for that stated in the order. It just said that the estate has to pay the fees of the petitioners even though they lost. And it assessed the fees of the personal representative directly against the personal representative, which is not the default setting in the statute. So again, our position is that the judge erred, number 1, in adopting the findings of fact and conclusions of law in the manner that she did, and also number 2, in the assessment of attorney's fees.
If you read the findings of fact that the judge signed, can you find a reasoning for assessing the attorney's fees in this case?
Yeah, in all candor, whenever you read it, you can see it. It's in the conclusions of law, but the conclusions of law that she's relying upon also assume that she has found for the petitioners in the verified petition, which she did not do. So, and this kind of goes back to, not to get too much into Steinberg 1, But we specifically had a discussion whenever I stood up here on that appeal about what you all were supposed to do as a court of appeals in reading into an order what the judge might have meant. In that case, if you recall, there was a mediated settlement agreement and a motion to enforce it that requested fees. The appellees in that case, they were also appellees, but the same parties had requested attorney's fees under the loser pays statute for a motion to dismiss. Our position was that had nothing to do with a motion to enforce a mediated settlement agreement. The judge in that case, without extrapolating or expounding upon why she did this, put a one-paragraph statement in that order that granted attorney's fees that said that she found that the actions of the petitioners, movements in that case, had inured to the benefit of the estate, and that that's a ground for a beneficiary to seek attorney's fees against an estate. Whenever we came up here and we talked about it, and what Your Honor said in your remand of that particular issue was, we don't know what to read into that. We need the court to tell us what she meant by that, which never happened. What I would submit is that if you read the history of this case, the remand, which happened while the verified petition was pending, and the proposed findings of fact and conclusions of law that the judge attempted to adopt, that was an attempt to sort of clean up the remand issue that wasn't handled separately. I would submit that that's also inappropriate.
Thank you. You used your time. Still have your rebuttal.
Thank you.
Good morning, Your Honors. My name is Stan Medlin. I am with Black, McLaren, Jones, Ryle, and Griffey down in Memphis. This is my first time before you, so it is definitely a pleasure. I'm here today on behalf of the appellees, Renea Steinberg, Judy Franklin, and Kimberly Steinberg. And as Mr. Vincent discussed, these proceedings are...
Let me ask you a question, Mr. Medlin. You said, are you on the brief?
Yes, Your Honor.
All right. You've already made an appearance then?
Oh, wait. My first appearance in person, Your Honor.
No, you made an appearance with the court. Okay, good. Go right ahead.
So as my opposing counsel discussed, these proceedings are largely focused on the August 30th, 2022 order on the verified petition to remove personal representative and appoint the replacement and for civil contempt. And so there are three issues I'd like to discuss with you today. The first before us is whether the trial court committed reversible error when it adopted the proposed findings of fact and conclusions of law submitted by the appellees. The second issue is whether the trial court committed reversible error when it required appellant to pay her own attorney's fees and then ordered that appellee's attorney's fees be paid from the estate. And then the third issue is whether the appellees should be awarded attorney fees on this appeal. So on the first issue, it is appellee's position that the trial court did not commit reversible error in partially adopting appellee's findings of fact and conclusions of law. Both parties have acknowledged a judgment entered by a trial court should be the product of that court's independent review of the facts. And as opposing counsel has made clear, the appellant questioned whether the trial court's August 30, 2022 order was fully based on the trial court's independent reasoning. They do admit in their brief, though, that it is at least partially based on the court's independent review of the facts. And so, and of course, their whole argument is based on the trial court's adoption of the proposed findings of fact and conclusions of law. And Your Honors, it certainly would have been preferable if the trial court had drafted its own findings of fact and conclusions of law, but it is not, however, an automatic basis for removal or reversal. Instead, the real question is ultimately whether that order was still based on the trial court's own independent legal reasoning and review of the facts. And we contend that the record does show that the court conducted its own independent review of the facts when it made its final and in full judgment. And we believe this is evident by the trial court's order, which ultimately did not grant the relief that the appellees sought in their petition. Now, opposing counsel has suggested in their brief that the trial court did not actually fully agree with the facts that it adopted in full. They point to facts stating that the appellant should have been removed as the personal representative and that she should have been found in contempt. But I do not believe that this necessarily conflicts with the final order, because the final order does not paint a glowing review of the personal representative's actions. They state that, but for COVID-19, the personal representative would have been removed due to the delays that she caused in the administration of the estate, but ultimately concluded that she should not be removed because it would be a burden to the estate at this point, because we're basically done administrating the estate now. And so it would have just been added expense. It wasn't necessary after all these years of litigation. And so there is further evidence that while the trial court did partially incorporate the appellee's findings of fact and conclusions of law, the conclusions of law were explicitly incorporated only to the degree that they do not conflict with the trial court's orders. So the trial court recognized in its order that the findings of fact and conclusions of law may differ from her own independent reasoning when she issued that order, and whether it's because she was pressed for time, because she was leaving the bench, we're not exactly sure what her reasoning was, she decided to just go ahead and sign the proposed findings of fact and conclusions of law. And of course, it should be noted that appellant did not submit a proposed findings of fact and conclusions of law, so the trial court, pressed for time, was only working with appellees. And so, opposing counsel, the appellant, is now arguing that the August 30th, 2022 order should be vacated, and they state that it's because it is not based on the independent review of the facts by the trial court. Of course, we believe that the evidence presented in the order and in the findings of fact would suggest that there was an independent review of the facts. Now, of course, would have been better if there was the court's own version, but we did not receive that. We received what the court submitted. But that order does offer some criticisms of the personal representative, but also reasonings for why it is not granting the relief sought by the appellees. And so that would be the first issue. And now the second issue, of course, is the attorney's fees. And the appellee's position is that the trial court did not commit reversible error in its assessment of the attorney's fees in the August 30th, 2022 order. And this is going to be reviewed under an abuse of discretion, whereas the previous issue was de novo before you. And so, appellant argues that the trial court's decision to deny appellant an award of attorney's fees should be reversed by this court. At the core of appellant's argument is the fact that the trial court did not grant the relief sought in appellee's verified petition, and that appellant ultimately fulfilled her duties as personal representative. While success can sometimes be a useful metric, it is not the true test prescribed by the case law when determining how to award attorney's fees. And so in the case of the state of Waller, the court discussed how the decision to award attorney's fees does not necessarily hinge on the success of a party's claims. Instead, the court explained that the correct test is whether the legal services inure to the benefit of the entire estate. Simply because appellant was not removed from her position and not found in contempt does not mean that the expenses of the lawsuit inure to the benefit of the estate. If anything, appellants procured these legal services to preserve her own position as personal representative, and as the trial court explicitly stated in the August 30th order, but for COVID-19, the personal representative's delayed administration would be contemptuous. So
why did the trial court do what the trial court did?
I believe with COVID, they had moved mostly to virtual, and there had been some issues with the appellant objecting to these proceedings being held over Zoom. It had just continued to push things down along. I think if you look at the record, you will see multiple instances where the court had to act to compel the personal representative to issue accountings. And I just think from the record, Your Honors, it shows that there was just unnecessary delays. And I think the trial court recognized that. Of course, it would have been better if they put it in their own words in a finding of fact, but we had the finding of fact that was proposed by the appellees and adopted in full, not partially like the conclusions of law. And so I believe because of COVID, the judge did give some grace there and did not find them in contempt. And honestly, Your Honors, it could be because she was about to leave the bench and just did not want to start that process with her soon leaving. But of course, I'm only guessing at that point. So it is our argument that the trial court acted reasonably and well within its discretion when it decided not to award appellant her attorney's fees, A reasonable person could certainly come to the conclusion that appellant's shortcomings as personal representative were the catalyst for this litigation, and that her legal expenses did not actually benefit the estate. And there is no abuse of discretion that would warrant a reversal by this court. Now, as for the trial court's decision to award appellees their attorney's fees, that award is appropriate because the legal expenses inure to the benefit of the estate. Appellee's petition brought additional scrutiny upon the appellant, and this accountability, coupled, as I was discussing, with those orders compelling personal representative to provide accountings and to act and to basically fulfill her duty, actually benefited the estate because it forced the completion of the administration of the estate. So accordingly, the expenses incurred by the appellees bringing this litigation can certainly be said to have inured to the benefit of the estate. And this is a perfectly reasonable position on which the trial court could base its decision. And again, there is no error that would suggest there is an abuse of discretion on this issue that would warrant reversal. And so on the final issue, appellant's attorney's fees for this appeal, we would argue that it is still subject to the same principle that if the expenses were procured, services were procured for the benefit of the estate, and that they inured to the benefit of the estate, that they should be awarded to the appellees, and they should come from the estate's assets. And so this proceeding is a continuation of the litigation over appellee's verified petition, and appellees contend that the expenses incurred continue to inure to the benefit of the estate. So, in conclusion, it is clear that the trial court understood the facts of this case, and that the trial court independently reviewed the facts when it was making its decision. The trial court's partial incorporation of the proposed findings of fact and conclusions of law does not negate the trial court's independent judgment and review the facts that it used when crafting this order. Additionally, there is no error that would lead this court to find that the trial court abused its discretion regarding the attorney's fees. Based on these factors, Your Honors, we ask that this court affirm the trial court's judgment. Thank you.
Thank you. I believe you have 5 minutes.
I would submit that Tennessee law dictates that it's more than preferable for a trial court to exercise its own independent judgment and to not adopt verbatim language of lawyers. Whenever the judge signed that document, which was unnecessary, that's essentially what she had done. She had also created a situation with the 2-page order that was entered that denied all relief sought for different reasons that was in the findings of fact and conclusions of law. The untenable position of having to then ferret out ourselves and now asking this court to do the same as to figure out what is not inconsistent in terms of the conclusions of law. I don't know how to do that. I don't. And that's the reason why judges are supposed to find their own facts and submit their own conclusions of law, notwithstanding requesting parties to have done that. Just first to quickly address the issue of fees on appeal. That's not, the case that they've cited for that proposition doesn't stand for that proposition. There's no basis in law for the assessment of attorney's fees on appeal for something like this. It doesn't exist. I would also point out that I think what counsel was presenting to the court a minute ago in terms of what the judge found, or at least in terms of what the findings of fact and conclusions of law said, sound like a good argument for their side to have appealed the order that did not replace and remove the personal representative, which they have not done. They don't complain about anything other than the assessment of attorney's fees for obvious reasons. So I would submit that those issues are not really relevant on this appeal, whether or not the judge may or may not have found that the personal representative didn't do everything perfectly is something that they could have appealed if they'd wanted to, and perhaps they could have had Ms. Steinberg removed and replaced, but they've not asked to do that. What they have asked to do is have attorney's fees flipped on their head. And Judge Stafford, you'd asked me a minute ago whether or not there's sufficient language or any language in the proposed findings of fact and conclusions of law that would assess attorney's fees to the estate for the appellees. I would point the court, and this starts in volume 7 at 990, paragraphs 9, 10, 11, 12, and 13 all address the magic language that's required to make that assessment. But if you look at the paragraph 13, what they're really talking about is enforcement of this settlement agreement, which was the subject of Steinberg 1 that was remanded for an assessment potentially of fees and how that inured to the benefit of the estate, and that never happened. This was an attempt to bootstrap a prior appeals remand issue into an order or findings of fact and conclusions of law that don't directly relate to the verified petition. And that brings me to the final issue is, what attorney's fees are we assessing? Attorney's fees for the appellees that allegedly inure to the benefit of the estate for what time period and for what activities? There have been no fee affidavits, there's been no hearing on it. It's just a straight up assessment of attorney's fees for something that we don't know what. And the reason we don't know what is because it doesn't say it in the order. And it's the same issue for the appellant's attorney's fees, which have not been applied for yet. We don't know what those are. We don't know what they're going to be. It's going to depend on if we can quit fighting about attorney's fees so we can ask what attorney's fees should be assessed. And if you take a look even at the findings of fact and conclusions of law, specifically at paragraph 9 in the conclusions at page 990 of the record, it says that number 10, the estate should not be charged with executor's legal expenses if the executor's conduct is not at the root of the litigation. There's no finding that what happened. There's no finding that anybody's conduct was at root of litigation other than the people who brought the verified petition that failed. It also says at paragraph 9, part of the respondent's duty, respondent being the appellant here, of undivided loyalty to the estate includes incurring only those expenses that are reasonably necessary for the proper administration of the estate. If anybody's trying to say that Ms. Steinberg, who by all accounts has now essentially completed the administration of the estate, absent this appeal and final distributions, is saying that somehow that none of her activities were designed to benefit the estate and the administration, I don't know how that could be made with a straight face. Because we're here with the same personal administrator that we've had since the very day that this estate was open. She's never been removed, she's never been replaced, she's never been found in contempt, not one single time. Almost done. The last thing I'll end with is that I heard counsel for the appellees use the word partially a couple of times, that the court partially adopted findings of fact and conclusions of law. What the court did is in the order. The two-page order says what it says. It says no finding of contempt, no replacement, no removal, a flipped on its head analysis of attorney's fees that is premature at best, and doesn't give any reasonings for that. Then attached to that, or at least within the record and signed, is a motion or a proposed findings of fact and conclusions of law that are diametrically opposed to the document she actually signed that was the only evidence of her actual independent judgment that was ever issued in this case, at least as to this issue.
Thank you.
Thank you.
Thank you, counsel. We appreciate your arguments, your briefs. We'll review the record and attempt to file an opinion at the earliest possible time. We'll stand in recess until the call of the docket this afternoon.